Now, the next speaker, and we're going to close the panel with Iain Mitchell, is chair of the Scottish Society for Computers and Law, is member of Scottish and English bars. He serves as the UK expert on the IT committee of the Council of Bars and Law Societies of Europe, and is past chair of its surveillance working group. Well, actually, you don't really need a lot of introduction within this context, so the floor is yours. You can stay here, and I'm going to bring a chair.
Yeah, I can just about squeeze stuff in here, so we're okay. Right, well, good morning, everybody. I'm afraid I'm going to be eating into your coffee break, which started a minute ago, but I thought that what it would be useful to do would be to give you an overview of the things both the Scottish Society for Computers and Law does, I'm the chair, but also look more generally at the kinds of issues that I'm dealing with in my various other roles, which key into a number of things that have been spoken about by the other speakers. The Scottish Society for Computers and Law has been around for about, believe it or not, I think we're heading up to our 50th anniversary. It's a very ancient organization, but we're primarily an educational charity. And our next event is on the 11th of May, where Victoria Baines, who's Facebook's trust and safety manager or formerly that of the European and Middle Eastern area, and formerly on Europol, is giving us a talk on the metaverse and criminal justice. And that's going to be in Brodie's Edinburgh office on the 11th of May. But if I can talk a bit more about the CCBE, it's the Council of Bars and Law Societies of Europe. It represents 1 million European lawyers and the bars and law societies of all of the Council of Europe member states. I got involved a number of years ago as the IT committee expert for the UK. But things began to take a turn when about 7 or 8 years ago, it came to attention that the US government had been spying upon a law firm that was advising the Singapore government in trade negotiations with the US government. Now, the CCBE is vigilant about the protection of legal rights and fundamental rights, including the Article 6 right to a fair trial, under which is the concept of legal professional privilege, and the Article 8 right, which is privacy, in the respect of which lawyers have an enhanced protection. So I wrote to the US government, signed by the president, and we got a anything but reassuring answer. They don't spy on American citizens. Well, you know, the fundamental problem is in Europe, we have fundamental rights because we're human beings. In the US, you get them because you're citizens. And if you're a human being but not a citizen, you don't get the rights. That led to the setting up of the surveillance working group of the CCBE, of which I was the first chairman. I did 2 terms, which is the maximum. So I did 6 years in that position. And as the years have gone by, we found that fundamental rights are under increasing, not decreasing challenge. It led to a number of papers that we did. I'll hold it this way so the people can see. But we started off with the CCB recommendations on the protection of client confidentiality within the context of surveillance activities. It was quite a bulky document, though it's bilingual, so it's only half as thick as it looks. I was responsible for really writing and putting that one together. And those recommendations have been taken up by Europol, by the UN High Commissioner on, Special Representative on Fundamental Rights, and a variety of other governments and NGOs, which I find very satisfying. We've been involved also with negotiating with the European Commission on the proposals that they have for production preservation orders for electronic evidence in criminal matters, which is this paper here we did on that. To headline it, it's basically, we believe, gives inadequate protection and inadequate judicial control of trans-border requests for criminal evidence. Don't have the time to tell you everything now, but you can grab me in the coffee break. That has fallen over into the second additional protocol to the Budapest Cybercrime Convention, which was before the Council of Europe, and we went along and lobbied very hard to ensure appropriate judicial controls. In the event, the final text gives the option of a declaration, but doesn't make it mandatory. So our attentions now are focused on ensuring that signatory states adopt the Declaration on Judicial Controls. There's another one which I did. It arose out of a discussion with the European Commission, Commissioner Jourova, about how we were unhappy about the way that national security is used as an excuse for surveillance measures. And the Commission said, well, you define national security, so we did. And this is the paper here, CCB Recommendations on the Protection of Fundamental Rights in the Context of National Security. But sadly, there is no internationally agreed definition of national security. When it was somebody attempted to put that into REPA in the House of Lords, but the government actually turned its back on that and said falsely that if we define it, it will deprive us of flexibility. Well, there's a filleting of that in here, and I won't trouble you with it now because time is short. But it's interesting that we chose as our introductory comments, when I use a word, Humpty Dumpty said in a rather scornful tone, it means just what I choose it to mean, neither more nor less. The question is, said Alice, whether you can make words mean so many different things. The question is, said Humpty Dumpty, which is to be master, that's all. And then we've done a paper on CCB considerations on the legal aspects of artificial intelligence, which I can really recommend to you. And I've been involved as one of the core group of European Lawyers Foundation, European a commission-funded paper on the guide on the use of artificial intelligence-based tools by lawyers and EU firms and law firms in the EU. I've been involved quite heavily individually on issues of biometric technology and fundamental rights, and we're now working on a CCBE paper on that. We just really started. So it's a fairly broad area of stuff that I've been heavily involved in, and things I'll happily share notes with you all over coffee. Meantime, quickly pick up a couple of other issues. Yes, we've been involved in court interventions as well. In the early days, we intervened in the Praken d'Oliveira case in the Netherlands, where the Netherlands Secret Service were basically snooping upon lawyers. We successfully challenged the Netherlands security services. I co-authored the brief to the US Supreme Court in the Microsoft warrant case. That was the CCBE's brief. I mean, you know, the bulk of it obviously was done by an American lawyer, but I provided the European input to that. And I'm presently involved in leading the CCBE interventions in the Jones Day and the Harting cases against the German Secret Service, again for, in this Harting case, electronic surveillance. And I did various papers on remote working and I'm involved in a number of AI proposals. I'm now vice chair because I couldn't be chair any longer of the working party, but they're happy to keep me at it. And Brexit has not made much difference. I'll be speaking on a European Commission conference next week about AI and electronic evidence. I've also been involved with the faculty of advocates doing consultations for them on the responses on the self-guided vehicles proposal, and also in the UK data protection a consultation where we took a fairly similar approach to the one taken by Open Rights Group. We were particularly concerned about about the fixed classes of a legitimate interest and dispensing in those classes with the balancing exercise against fundamental rights. That I think is hugely important, having just recently part one, I'll unpick later what that means, but we won the principal argument in a case I had before the Employment Tribunal in London, which was about a product called IntroHive, which basically snoops on employees' emails. So and that was once because of the necessity to balance against fundamental rights. And if that wasn't there, that argument would not have been won. With Open UK, I'm their sort of honorary QC, and we've been engaging with the government rather more successfully in all matters open. And the latest edition of the book on a open a source software is coming out from Oxford University Press in September. And finally, with the Worshipful Company of Information Technologists, whose tie I'm wearing today, I've been heavily involved in questions of ethics in the technology industry. So that gives you a very broad overview of the hugely diverse amount of stuff that I have been doing. I'll happily engage with you on any of the topics. I'll maybe grab you to help give us some more talks to SSCL, and I'll look forward to making some more interventions as the next 2 days progress. And meantime, I probably just within the time managed yet again successfully to disguise my ignorance of the subject about which I'm talking. Thanks.